but the general trend is that mediation via, I'll just use Zoom to refer to all the different online platforms, is here to stay, as you've said. But again, it needs to be strategically considered along with all other decisions that attorneys and neutrals have to make when they are either representing a client or performing for clientele as a neutral.
The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress.
Settle! Settle, 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 settle!
I don't want to settle.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on.
Welcome to Mediator in the Middle. This is your place to peek behind the curtain of what a mediator is really thinking. I'm your host, Abe Melamed, a litigator turned mediator. In this series, I, along with world-renowned mediators, will offer you, the clients, the lawyers, the parties to mediations, tips and tricks on how to be more effective in mediation and ultimately get yourself the best result possible. Thank you for listening. Please enjoy. Welcome back to Mediator in the Middle, a podcast about mediation by mediators for litigators and their clients. I'm your host, Abe Melamed. I'm a mediator specializing in helping parties resolve employment, business, and tort disputes in California, New York, and Arizona. Today, we're really honored to have a special guest, Ruth Raisfeld. Ruth is a mediator in New York who I used frequently when I was a litigator. She's somebody who I think more than many others is a very effective mediator with really the broad spectrum of potential clients. She can be very empathetic when a client needs it. She can be very evaluative when a client needs that too. And so I can really vouch for her skills as a mediator, and we're really excited to have her here today. Thank you, Ruth. Welcome.
My pleasure.
So a little bit of background that I know just from your profile and from having worked with you, I'm going to just go through and you'll let me know if I miss anything, but you've been mediating for close to 20 years, maybe more now, and been a lawyer for 40 or so. Do I have that right? Is that dating?
Yes, yeah. Well, to be specific, it's 42 years since I graduated from Fordham Law School, and I've been mediating for 22 years, having come to that better place following 9/11, and that was what they now call an inflection point for a lot of people, just as the COVID epidemic has sort of generated some new career transitions.
Sure, yeah, but I mean that's quite an amount of time, so I applaud you for sticking with it. Not many people can last that long of a career, even for the first 22 years or 20 years as a lawyer, and then let alone another 22 as a mediator and doing alternative dispute resolution. And your background, which I know is you have a lot of experience with employment cases in particular, but you've handled thousands of cases, I'm sure, at this point, and single plaintiff, multi-plaintiff, class, harassment, retaliation, wage and hour, all these different types of employment-related cases.
Correct.
And you've been recognized. I could go down the list of credentials, but just to name a few, you've got, the AAA has recognized you for various credentials. You got the National Association of Distinguished Neutrals, which we all know is, maybe the preeminent association of neutrals that exists. Distinguished Neutral College of Labor and Employment Lawyers, super lawyers, best lawyers. So, you've lots of accolades, but really it's the experience that I think speaks the most. And we're excited to have you and to talk about an interesting topic, a fun topic, something that I think is really important today, just as we just talked about that kind of pivot in the pandemic time, one of the big changes we've had, which is shifting virtual. And, I know there have been a handful of articles about this in the past. There's certainly been some discussions about it. There were some new statistics from the National Academy of Distinguished Neutrals that we were going to talk about. I don't know if you had an opportunity to clear that, so to speak. But why don't we start there?
So let's first talk about the urgency of neutrals, mediators, arbitrators, judges, of learning how to conduct all kinds of conferences with attorneys and litigants online in one mode or another. And I have to say that the mediation community quickly, and I'm talking about maybe the last 2 weeks of March, quickly pushed out training in how to actually conduct these online proceedings. The courts, I believe, were a little bit slower to do that, but
they usually are.
Because the judges get paid whether they conduct litigation motions or not, whereas mediators got to eat, and our arbitrators got to eat, and we get generally paid by the hour, by the case. So it behooved us to quickly train. And the interesting statistic that this National Association of Distinguished Neutrals has recently published, and they've done several surveys of litigators and neutrals, is that at the time of the pandemic, only 2.5% of polled litigators had participated in online mediations. Now, looking back to September of 2020, 94.5% of mediations were conducted online on one platform or another. That's an incredibly high number. Shift. And now it's shifted back to about 75% are conducted online. But the general trend is that mediation via, I'll just use Zoom to refer to all the different online platforms, is here to stay, as you've said. But again, it needs to be strategically considered along with all other decisions that attorneys and neutrals have to make when they are either representing a client or performing for clientele as a neutral.
Right. So, yeah, and I can remember, I would say even going back to 2018, 19, right before the pandemic, I remember, we would go to the EEOC for a mediation, and there'd be some remote party, there'd be an adjuster or someone that needed to be there, and they'd wheel in one of those big TVs that we used to have in elementary school and try to hook it up, and it was no one wanted to do it and no one knew how to do it. But I agree, it's been such an interesting thing to see how it's pivoted, I'd say almost exclusively virtually throughout the entire pandemic, and then now the vast majority of it. And so I think a good place to start would be, how do you go about, for those who don't know, who haven't experienced this yet, or maybe want to learn from our experiences, how do you go about conducting a mediation virtually on Zoom? How is it different, just structurally? How does the rooms work, that sort of thing?
Right. So first of all, if you are going to hold yourself out as a neutral today, you have to have the technological skills as well as the process skills and the subject matter skills. So the day to learn how to set up breakout rooms is not the date of your first mediation. And there's plenty of training available
for sure
online. And I haven't gone for substantive mediation training in many years, but I'm assuming that the question of logistics is addressed in any training for neutrals. I have modified my mediation agreement to begin with to, I have a clause that says if we mediate via Zoom, it has the same purpose and effect and same confidentiality as if we were holding it in person. That's a clause I added. And I also have a sort of Zoom mediation addendum, which describes the process of negotiating virtually, that a camera will be on, that there will be audio, that it's confidential, that people are to find a confidential setting in which to have the to participate. The reason that I sort of break out a special addendum or a second agreement is I want everyone to sign on to this, that they understand that although we're not appearing in person, I want the same degree of attention and effort and persistence to take place. So I have a supplemental agreement. I don't send out the link for the Zoom mediation until a few days before, mostly because I'm not as adept at the Outlook save function.
It's
and I want to remind people to pay attention. And so I feel, and I know Abe, you talk about this a lot, the idea of front loading. I want the mediation itself to come up to have like a bit of a crescendo to it. So if it takes 6 weeks, if 2 months or 6 weeks or a month to set up the date, in those 10 days before the mediation, I want people to start to like sit up and take notice. Now you have to submit your position statement. Now you have to submit your the mediation fee in advance. And after I see that those things are taking place, then I send the Zoom link.
You'll set up the Zoom and send it over.
It's sort of like the carrot out there to be sure that all these other scheduling matters have been met.
That makes sense.
Yeah, and the only platform that I use is Zoom. I know people use Teams. I have found, I think that Zoom is the should get the Nobel Prize
for how it's adapted,
for how it really has saved civilization to the extent that we can say that it's civil. I think that Zoom really enabled business to continue to be conducted.
Yeah, I agree. And we're not sponsored by Zoom, but I completely agree. I think early on in the pandemic, and maybe this was even one of the statistics in the NADN's report, but early on, I think people were using a variety of platforms, and there are some platforms that are being built for this purpose. There's, I know Mediate.com, Jim Melamed is working, no relation, but he's working on something, and I know that, ADR Notable. So there are a handful, but I agree. Zoom has been, I think the most phenomenal platform. And in part, I think it's because they've been so successful at building in the confidentiality safeties that are necessary. There's so many therapists that are working with Zoom or doctors that are, and so they really spent a lot on that structure. And that's such a critical element of mediation, is knowing that there's security and safety and the confidentiality of the process. So
right, and it's also very smooth. The technology is very smooth. But let me just emphasize one other thing that I insist upon, which is that in my instructions, I say you need to be prepared to participate via desktop, laptop, or iPad, and not exclusively
cell phone.
Phone. My issue with that is the connection isn't as stable. People tend to get calls or text, which interrupts the concentration, but also it requires me to stop doing what I'm doing to readmit people. Right, and that people happens a lot on the cell phone. I just think that you need to, as the neutral, in our increasingly informal and might I say lazy society, I think that not using the cell phone helps to emphasize the need to focus and to be persistent, and not to just treat a mediation that we've convened with any less seriousness of purpose because you're doing it via phone. Do I get 100% buy-in on that? No, but I warned you in advance. So
yeah, at least I let you know. No, I think that's a great point. I remember early on conducting several Zoom mediations where the plaintiff, let's say, was in the back of a car on a cell phone or something, and it really doesn't work. It interrupts that flow. But I think when we get a little bit more into just the way that people should conduct themselves in the mediation, I think that first point you made is really critical, and that is the parties need to take it as seriously as if we were in person. And I think they have started to. I think, now you see some hybrid. We'll talk about that too, but you'll see sometimes the client, plaintiff will go to the lawyer's office for the plaintiff. Defendant might be in one office with a corporate rep, and then the adjuster is somewhere else. So you get some sorts of mixtures where people are taking it seriously, but I think that's a really great point. And as far as just kind of the structure, if people, I think, like you said, people can find a lot of information online, but what I wouldn't like people to understand, if they haven't experienced this yet, is it really operates very similarly to how we would in person. We have separate rooms. The parties stay in their separate rooms. They don't move unless we tell them to move, so to speak. And we can move them around very quickly from room to room if we need to bring the lawyers together. I just did an episode with gig last week where we talked a lot about the attorneys meetings. I know that's something that you do, often. I think we've done that several times
Yes.
when I used to use you as a mediator.
Let
So
me
I
add
think
one
it's a
other
great
point,
factor. Yeah. Mm-hmm.
Abe, that we didn't cover in our
Discussions previous.
in our
Yeah.
outline about this, but it occurs to me as we're speaking that just as in in-person mediations, the question comes up: are we going to do a joint session?
Mm-hmm.
And I think that lawyers typically do not like joint sessions, even in person. Some do, most don't. Again, they think that it's going to cause posturing and provocation. Done properly, it doesn't, but it's, that's just my view. And I do talk to counsel about whether or not there's going to be a joint session and whether they need to speak. I have come around to the belief that joint sessions are particularly, let's say this, I believe in a joint session, and I'll describe to you what I do, but I have come to the belief that counsel should not make opening statements, that the joint session is an opportunity for me to lay ground rules with respect to process. So what I do logistically is generally I ask the plaintiff's side to join at 9:30 Eastern Standard Time, and the defense side to join at 9:45. I could adjust it. It could be 9:45
Sure.
or 10, but I stagger the parties coming on so that I could get the one side situated, make some casual opening remarks to them to sort of build rapport, put people at ease. Then I say, you have to excuse me, and now I'm going to admit the employer's side. That gives them a chance to talk to each other, like, oh, I like Ruth, I don't like Ruth, or she's scaring me, she's not scaring me, this isn't as bad as I thought it would be, blah, blah, blah. And then I do the same thing with the defense. And then I have a joint session because I always believe that you should know who you're talking to. It's good for rapport building. And again, it sort of emphasizes the formality of the process and allows me to sort of give everybody the same,
same spiel without repeating it.
The same spiel without repeating it. And the same sort of questions come up, like, what do I say? What do I do? I always say, you're going to see everybody who's there. All you have to do is say good morning. Well, I don't want to be in the same room. It's okay that you're not in the same room. It's just a couple of minutes.
Especially now.
And if you're going to litigate, you have to show that you can be fully participative.
Yeah.
So again, I don't skip any of those steps.
Yeah, I think that's, meaning in the virtual setting, you follow the same sort of routine you would if we were in person.
Pretty much, but
Yeah.
Obviously with different, I give everybody my cell phone number in case we
Sure.
get knocked off. I do not use the chat function.
Mm-hmm.
It's just like too much. But
going on at once.
I do give them my cell phone number. I do have attorneys who, will text me. But generally speaking, I use the ask for help.
The raise the hand, ask for help. Yeah.
For the breakout rooms.
Yeah. And so it sounds like it's really going to operate when the way you conduct it, which I think is how most do, is very similar to what it's like in person. And I think that's a really great pivot point to what are some of the differences between a virtual mediation and in-person mediation. I'd say even some of the values that we've seen, and not just some of the things we kind of live with, but really focused on the parties and how they can benefit from your unique perspective. I think talking about document sharing or talking about how to be more human and making sure to have eye contact or things like that. But what are some of the things you found to be different and maybe even better in the Zoom context?
Well, I have to say that I have found that I think most mediators agree that the success rate is pretty much the same.
Yeah.
Which is sort of remarkable in a way. And that's why we're pretty sure that the online method will continue. But in order to have that success, I think once again, the mediator has, look, I not to be pejorative about it, but sometimes I feel like a kindergarten cop. I encourage the attorneys to dress like attorneys. I encourage them not to bring the dog into the room. I encourage them to make sure that their client, if they're not with them, and by the way, I would encourage them to have their client with them now that vaccines are in place. But if they can't, and there's reasons for it, I discuss it with them. But the one problem I find, which was also true in in-person mediation, is that the lawyer during gaps ignores the client.
Yeah.
And doesn't spend time on the client's emotional needs. And has the client had something to drink? Has the client had something to eat? Does the client have a babysitting issue? Is the client depressed? Does the client need someone in the place where they are to give them moral support? It's not just a time for you to be drafting some other document in some other case. There has to be some emotional intelligence.
Yeah, and building credibility with the clients themselves, especially if you're going to help in the process of getting a resolution. 100%.
Yeah, but I think the mediators are typically good at that, and sometimes
the lawyer's not. Yeah.
The lawyer is busy and doesn't want to have downtime, but doesn't realize that the downtime, you have to spread yourself. You can't just say, I'll be back in an hour because I have a court appointment. Right. Although that could happen, you have to tee it up, let the mediator know. So then maybe I'll tend to the client a little bit more, So the mediator, the successful mediator, I believe, is attuned to the dynamics that are, how long have you let the people talk? Should you sort of knock on the door and say, would you like to speak to me again? Sometimes people need to be reminded. But I think one of the other things that is remarkably effective in Zoom mediation, and it might be because the lawyer is not necessarily in the room with the client, that it's very easy on Zoom to really look at the client's face.
See micro expressions, see how they react. Yeah.
Correct. And you're almost not as close to them as you are in person, because the mediator might be sitting at the top of the table and the client is across the table or at the end of a big conference room. And even as the mediator, I'm sure there are times where you say, you know what, I'm going to go sit next to the client instead of being at the top of the table. So all of these things are still present with Zoom mediation. But I do find, and I think some judges have commented on this also, that you really do get, you're not looking at the side of their head. You can see their face. And that's true, of course, of the lawyers too. You just sort of get a sense at a certain point during the day, now we're talking. Now,
you can see how they react to a piece of evidence or to some comment Yeah, and,
I don't know if you want to go ahead.
Well, I was just going to say something that I think is really critical about that, and it's something I spent months and hundreds of dollars researching in order to really determine, is create the best environment, studio type environment in your home, if you're going to be in your home or in your office, to make it more personal. I have the Yeti Nano as a mic, and I have the Logitech Brio as a camera. The Logitech Brio kind of tracks your eyes so that when you look dead center at the screen, it looks like I'm actually staring at you, as opposed to people who are, looking up at the camera or around. Or so I think just being thoughtful, that's a piece of advice I would give to lawyers that I'm sure you have similar experience, but being thoughtful of how to do it so that I'm staring straight at you. And in the same respect, if the lawyers and the clients are staring straight at the camera, so to speak, the mediator is able to read them better, because then they are actually just looking at their face.
Yeah. I mean, I've had instances where the lawyer has two monitors and they have Zoom on one and they have their email on the other, and you find yourself looking at the side of their head. And I always say, not doing that.
No, face me front forward.
Right.
Yeah.
And then also there's the issue, and I have the same issue in person, where there's a young associate or a paralegal, somebody seems to be transcribing. I don't allow that to take place. If they want to take notes, they can take notes with a pad and a pen. Although
or mute themselves.
Yeah, or mute themselves. But one of the topics that you wanted to address is the screen share, which again is a fairly easy element to use, but not everybody's that good at it.
Yeah.
And so I caution attorneys when they are thinking about preparing materials. I say, if there's anything you want me to read during the mediation, I want to see it before the mediation.
Yeah.
I might agree that we can turn to a particular document via share screen, but don't hold back, because it's very hard to absorb a document on a share screen and work with it if you're seeing it for the first time during the mediation. So that's another instruction. And again, it all has to do with how much preparation you're going to do, because if lawyers are used to like putting their file together the night before the mediation, that doesn't help the mediator.
No, it's shocking to me how often in my pre-mediation phone calls a week or two before, I'm helping them develop what documents will be helpful. But that's the question I always say is, give me as much ammo as you can get me to use with the other side, and then just start talking about what they should gather. But I agree, giving it in advance is critical, especially because, frankly, if the lawyers don't have a lot of experience with DocuShare or sharing the screen, the mediator will. The mediator does this all day, every day, and let the mediator be the one to do the sharing. But I found it most helpful, and I'm curious if you find the same, but really mostly helpful to show the other side in attorney meetings, because the mediator's done their job. They've read the briefs, they know the exhibits, but you might have documents you're not willing to share with the other side in advanced mediation, and I say, well, listen, we've got so much privilege and confidentiality in mediation, let's share it with the other side in an attorney meeting. And you can do that on a screen share with Zoom, where they're not taking pictures of it, or you'd get a notification, and where you can really just they can explain it. So I see that as a big value, that it used to be we were shuttling all these documents and we had to be the custodians of them, and now it's just kind of throw it up, see what happens.
Right. I mean, that's a good technique. I find that I almost feel like I'm getting paid so that they don't have to be in the same room with their adversary. So that sometimes there's some resistance to that. Let's talk.
Yeah.
Again,
let's talk in a joint way.
You have to test everything. It's a good idea.
I think it's helpful. So, one of the things that I'm curious about your experience with, we talked about this briefly, is I've heard lawyers have concern about the inability to make a dramatic exit at a point in the mediation, to start putting their coat on and walking out and letting the other side see. And obviously you can just drop off the Zoom, but then the other side doesn't necessarily see that. Now you have to communicate that. Do you find, I know it's a little bit theatrical, but it is an element of the mediation process, do you find an effective way to do that even in the Zoom world, or do you think it's not effective at all? Yeah.
Well, I think that kind of walkout gesture usually comes late in the day, where someone will say, look, I'm just packed up, I'm going to the elevator, and then somebody chases, no, come back. I think that can be effective. In Zoom, that can be done when somebody says, look, I don't think this is working. I don't think this is working well. I have to pick my kid up at school, or I have another, I have another call. Maybe we should schedule another day, or maybe we can schedule a touch base. And I'm like, don't give up so fast. Let's. So there are ways to stage a walkout, not quite as dramatically. One of the things that I do is if I see that the business person is getting annoyed and wants to bolt, I say, you know what? I say, go bolt, keep your lawyers here. they can be in touch with you via email, text, whatever. You come back, and that seems to be a pressure valve releaser that helps. And if you're engaged in a kind of discussion where, people are going up 10, down 10, up 10, down 10, and we know as mediators, sometimes you just have to do that to burn through the hours.
Yeah.
Let the person come back at 4 o'clock or 5 o'clock.
When they have to make a real decision.
When we're really starting to, come to the settlement zone.
Yeah. I think that's a great point. Sorry.
No, I was going to say, you're in California. I'm in New York. May I venture that there's a little more histrionics in California than in New York.
It's been interesting to see the variations between the two markets, because I mediate in both of them now, and there's a lot of differences in terms of what a mediator's proposal is, in terms of how the parties practice. But yeah, there probably is more theatrics in California than in New York. And yeah, I think it's interesting what you were just saying about, the ability to jump off and then to come back on. I think that has a lot of values across the broad spectrum. It used to be, you could say to a client if they needed it, why don't you get up, go to the bathroom, wash your face, go get a snack, walk around the block. I think here you really have the ability to say, you're more comfortable in your house anyway. Go log off of Zoom and go watch a 40-minute TV show and get back on if you need that. Do what you need to do. But obviously you have to balance that with trying to keep them still in the mindset of I'm in a mediation and not out. So I'm curious if there are other things or other values that you would like to see more attorneys take advantage of, or more of their clients take advantage of in using the Zoom process. And the one thing that I'll just say that I think is critical, I make it a very significant point at around noon to stop everyone and say, order some food to your house. I actually am one of the pioneers of sending Grubhub credits to both sides in advance of a full day mediation to say, use your money, go buy the food, because I think that's something that I realized when I was litigating and then ultimately shifting to mediation. Is I had a client, I was representing a client early on in the pandemic, and at the end of the mediation at 7 p.m. he said, oh man, I'm really hungry, I'm going to go get a snack now. And it hit me like, wait, you haven't eaten all day. Yeah. And so I think that that's an example of something that people might not be thinking about. If you're the lawyer, make sure your client is set up to eat food, because if their blood sugar drops, if they're hungry, it's not going to work.
Right. So, and that's very fine maternal instinct you have. And as a grandmother, wife, and mother, I'm always worried about making sure people eat.
That's important.
And by the way, it's not my style, but I know that there's people who need to have a cigarette.
Yeah.
So I say, if you want to smoke, it's fine. I'm not in the same room with you, so I'm not going to inhale the secondhand smoke.
Yeah, exactly. Go outside.
Go out, get some air, go out. Yeah, all those things still, you have to pay attention to it.
Yeah. And I think that's another example in Zoom where you might not, I think that's the cautionary tale that I see is just lawyers watch out for your clients, especially because the mediator might be in the other room for 45 minutes. You're sitting there with the client. The client might start getting anxious or whatever it is. Now it's, instead of saying, let's go take a walk, or now it's just go log off or put yourself on mute and close your camera and then go outside, but come back when, in 15 minutes or something.
Yeah. But also one of the things that you just mentioned, there may be large periods of time where you can't be talking. You have to prepare them for that. So there may be, I may be in a breakout room for a while with the other side. I may ask the attorneys to meet me in an attorney's room. None of that's unusual. And then if a caucus is going on a particularly long period of time, you use your phone to text the lawyer, say, I'm still talking. Maybe it'll be another 10, 20 minutes. But to always be
in contact about it.
In contact and watching, the 360 degrees of humans that we're dealing with, despite the technology.
Yeah, I think that's a great point. One other thing that I'm kind of curious about in this same rubric is, dealing with larger groups or dealing with clients and their lawyers together. Have you found at least that mediations are more effective if the lawyer brings the client into the office, even if the other side's in a different office on a Zoom and the adjuster's in a different office, maybe a different state on a Zoom? But do you find that's more effective than just having all the parties on their own on Zoom?
I absolutely think if it's safe, that particularly the plaintiff, should be in the same room with counsel. The in an employment case, which is mostly the kind that I handle, you're dealing with an individual on one side and a business, be it a small business, large business, employer on the other. And employers are used to conducting business over the phone, having virtual meetings. They're much more used to long distance negotiations.
Technological fixes. Yeah,
right.
That makes sense.
Plaintiffs are not, number one. Number two, when they're sitting in their own bedroom or living room or kitchen, they feel very empowered. To the extent they have any power, that's their comfort zone. That's where they are the king of the hill. When you're in a litigation, when you're in court, when you're in a deposition, when you are asked to appear in front of a judge, that's not your turf anymore. That's where you're going to be telling your story. So I think that that they're lured into a false comfort zone, that if they're in a law firm and they see stacks and stacks of books and piles of papers and people going back and forth, that's not a friendly atmosphere. And
it's a little more real.
It's more real. And it's more like what they're likely to experience. Again, law firms may be more hospitable environments than court. So they might be able to sit back and pet their cat and say, no, you're not paying me enough. No, I don't think so. I'm going to litigate. When they have really zero clue of what that actually
feels like.
Yeah.
Yeah, it's really interesting, because I think that I've seen kind of both sides of that same coin, which is that I think one of the benefits that you do see in Zoom is the parties are more comfortable to begin with. So when you have sexual harassment cases, rape cases, serious injury cases, things like that, where the mediator needs to build a rapport with the client throughout the maybe the first half of the day, when they are in their own comfort zone, I find they tend to be a little bit more comfortable in building that rapport and a little quicker to do it. But I think that's a great point, that at the same time, you don't necessarily get that same litigation feel. And maybe that's one of the values of doing the joint session, how you described it, is even just to make them feel a little uncomfortable of what this is going to actually be like. But
right.
It's an interesting.
Yeah.
Yeah.
But yes, the rapport building at the beginning of the day is important. But also, as lawyers, we are used to working very long blocks of time. So to get from 9 to 5 and still not be done, that it's that extra push from 5 to 7 when the deal gets done.
Yeah.
So that's sometimes when I wish that I was in the same room with them, because that's when our own energy flags, but that's when we're really getting the deal done. So, as mediators over Zoom, you also have to keep your energy level up the whole time, which is one of the, tough things about being a mediator. You can't go, I'm tired too. All right,
no naps.
We'll do this another day, because everything slides back. Now that's typical of an employment mediation. Commercial mediations sometimes do take multiple days, because there are complex issues that need to be researched or adjusted. There's not another partner to talk to, or an investor, or they have to go back and talk to their accountant. We don't have as many reasons to regroup. Although I'm finding that there does seem to be a tendency. I think people get tired after 8 or 9 hours on Zoom, and they're like, you know what, Ruth, can we do the rest of this by phone, on subsequent days? And I can sense when it's time to break.
When it's time to separate.
And I think the fact that people aren't like catching a train or having to feed a meter
It's less pressure.
Is less pressure, and they do need to sleep on it a little bit. And I mean, while we're talking, I'm getting text messages in follow up on mediations that were held via Zoom. So you have less ability to hold everybody there
and really kind of push for the deal. I mean, I mediated a case once as the litigant where we started at 9 a.m. and we ended at 3 a.m.
Yeah.
And,
but
it's like once you're
less.
right, but once you're on that roll, I think that's an interesting point about the Zoom context is it's a lot easier to say, well, you know what, let's regroup another day, let's log off. But I think that if you have the clients going to their attorney's offices, maybe you still have some of that control of they do still need to catch a train or get in a taxi or walk, whatever it might be. It's a little easier to say, you know what, why don't we just stay here, keep this momentum, and see if we can get this done. And if we can't by X time, we'll regroup.
Right.
So it might be an interesting thing for lawyers to try if they haven't yet to bring those clients in again when it's safe.
Yeah.
So another question I have that I'm really curious what your experience has been is, have you found lawyers to be less prepared? Do you find that the lawyers themselves tend to show up at the mediation less developed and not as, without as much information about the case? Because I've seen in some cases, it seems to me that they're like, well, I'm going to roll out of bed and hop on my computer at my dining room table. Whereas the lawyers that I find are on Zoom in their physical offices, I think tend to be more prepared. Like they had to actually go to their office to sit down and do this mediation. They're taking it a little more seriously. So I'm curious if you've had that experience and what kind of cautionary note or advice we can give to the lawyers out there.
My view is that they are equally unprepared in both mediums.
Fair enough.
They're equally unprepared or underprepared.
Right.
So whatever their habits are, they seem to be they seem to be the same in both settings. Now, look, I think that there's a tendency. It's harder to meet with the client perhaps in advance, so they do it during the mediation.
Right.
That is not a recipe for success.
Yeah, I agree. I think the more they can prepare, and that is really the front loading the process piece to this, is the more you can prepare, the better. But it's an interesting thing where I think at least lawyers should be thinking about this is, am I going to actually feel compelled to be a little more prepared if I go into the physical office versus doing it from a home office or something? I mean, I'm not knocking home offices. I'm in one right now, but
this is a general societal issue.
Mm-hmm.
Judges have had to issue rules that appearance before a judge via Teams or whatever they happen to use is tantamount to a court appearance, and the attorney should be wearing attorney clothes. Okay.
I had a case, one of the last litigation files before I shifted my practice to mediation, where a partner at a very respectable firm showed up on a Teams meeting from the court for an oral argument, expecting it to be audio, not realizing it was video, and he was in a bathrobe. And,
I mean, it's just, it's just silly. So certainly, as I said at the beginning, the general informalizing of institutions,
in general.
Institutions, of the rule of law, of creating a legal document have been eroding. And someone who's been doing this for 42 years, I do not subscribe to the erosion of those norms. Mm-hmm. And I think that there's merit to them. But certainly, I also don't want someone to email me a 20-page mediation statement with exhibits that go from A to double Z.
Just to get through the alphabet, yeah.
No, that creates a burden on me to read documents online when I may want to make notes on them and have them in front of me. Mm-hmm. So again, if it may be easy for a lawyer to just throw everything up in a PDF and leave, but they've left me with
holding the pieces.
Yeah, and I don't have a paralegal, and I don't have a law clerk, and I don't have an associate.
And it's not your job.
And it's not my job to print out the 20-page document. And when I see something like that, oh, I'm sorry, Ms. Raisfeld, the materials are voluminous, so I'm sending them to you in 10 different emails. And I call them up and go, no, that's not how we work.
If it can't fit in one email, I
don't want it. Have you heard of FedEx? Have you heard of FedEx? Use it. Oh, I don't have an assistant. Well, figure out a way to get those documents to me if you want me to help you. So, Abe, my view is mediators best help those who help themselves. I'm not a magician. I'm a mechanic. I need the tools. I need the materials, and then I can help.
And then you can help too. Yeah.
Right.
Yeah. So, and that's, I think, a good pivot to the last topic, which is just the technology involved. Do you have any specific advice? I know we talked a little bit about having clients test it out or things like that, but obviously it cannot be the first time you've logged into Zoom when you're getting ready for your mediation. What advice do you have for the lawyers and for their clients, or for the lawyers to make sure their clients are following the advice?
Yeah, well, this deep into the use of online dispute resolution techniques, I think people are pretty used to this mode of communication. If they're not, I do encourage I'll call the lawyer. For example, we have the situation of translators.
Mm-hmm.
Now, I don't need a court certified translator. I could have, a friend. I don't, because I'm not
family member or someone. Yeah,
they're not testifying.
Right.
As long as they sign the confidentiality agreement. If there's a paralegal that the attorney has who can translate, that's fine too. But yeah, you want them to be comfortable. The question is, do they have to attend? Again, yes. Now, in a class action, do you need all 20, 40, 50? No.
No, the lawyers and maybe one or two, yeah.
But if there isn't a client, it raises a question in the minds of the defendant. Why do we have a plaintiff's lawyer demanding $5 million and not one client is there?
Mm-hmm.
So all of these sort of subjective strategic decisions have to be made thoughtfully. And the fact that something's online shouldn't, invariably it does, tend to encourage people to cut corners.
Yeah,
but,
be a little more lackadaisical about the process.
Right.
I think that's great advice. I think it's a broad spectrum. It's just take it as seriously as if you were in person.
Right. And the other thing that I would just add, and I know we're sort of running out of time, is it's perfectly okay, and I encourage counsel to call a mediator who they're thinking about using. Ask, could we talk over Zoom? The primary consideration shouldn't be whether the person has a date.
Right.
It should be, is this somebody who my client will relate to over Zoom?
It's a good idea. You get to actually feel what that mediator's like. Do they know how to use the technology? Do they come across well on Zoom? It's a great point.
Right. So has it ever happened? Yeah, maybe once
once or twice, yeah.
But I'm always encouraging, and very often if somebody who I don't know, obviously in our area we have a lot of repeat players. I mean, Abe, maybe you and I had 2 mediations, but we built rapport. So you can just contact me and say, Ruth, do you have a date? But if I've never met the plaintiff's counsel, or I'd never worked with the defense counsel, I sometimes just call them. Do I want to work with this person? Because I want to be effective.
You got to choose your clients too,
I have to choose my clients too. And if they only want to text, email me about dates and I don't know them, maybe I'm not going to take that case.
Yeah. No, and now with Zoom being so easy to schedule and just hop on even for a few minutes, I think that's a great point. You actually can get a face-to-face interaction in. So I don't want to keep you much longer. I wanted to ask if you have a good anecdote from, maybe a cautionary tale. I'll give one little one. Is early on in the Zoom process during the pandemic, I had a mediation where I had unrepresented defendant who was just very, very difficult. And I was working with multiple screens but hadn't perfected it yet, and I had not moved myself into a separate room on one of the screens, and I let out an audible sigh of frustration. And they heard it, and I played it off a little bit, and then I kind of turned it into, sorry, it's a process. It really, takes a toll also.
Yeah.
But I think it's a good cautionary tale that I learned from, that lawyers and their clients should be aware of, which is, you're doing this virtually. It's great. There's so many functions and features, and you can mute yourself and you can turn your camera off. And, we don't want to be one of those newscasters who's canceled for doing something wrong on camera, but just be conscious of that. Think about it. Make sure you're actually on mute, whether it's taking a call from your doctor that calls in, or it's, you're having a conversation with the adjuster that you don't want the mediator to hear, or whatever it is. Be conscious of that. That's my anecdote. Any anecdotes from you?
Yeah, I think obviously we all had some growing pains in that neighborhood, but very often the lawyer wants to set up their own Zoom with their client.
Mm-hmm.
So, or an adjuster who they don't want the other side to know about. So you are in two Zooms at once, one that you're conducting and one that they're conducting. And if you are participating in the other Zoom or whatever system that they use, you better be sure that
make sure you're talking to the right person.
That you're talking to the right person, and that you're. What I do just to be sure, I'm sure, is I literally go into the other room to talk to that other Zoom with the door closed, because I did it once where they said, Ruth, we heard everything you said. They're like, ay.
Wow.
I think Abe, everybody understands.
You click the receiver. Yeah, you click the receiver 3 times to make sure you hung up before you speak about the person.
Exactly.
Yeah.
So thank you for asking me to participate. And
thank you for joining. I do have one last question I like to ask, is just what do you find most rewarding about being a mediator? What do you enjoy most about it?
What I enjoy most is that I am not making motions for summary judgment. The other derivative of that is that I feel like I am saving people from themselves, from their lawyers, and from the really degrading system of litigation. I actually made a note to myself that with respect to that question, that I feel like I am that the mediation process is the solid life raft off of a rotting ship. And when I'm able to steer that to a successful conclusion, I feel like I really helped this person. Because litigation it's even at the end of the very long process, when you win, you don't get a lot of feedback from people saying, oh, that was worth it.
Yeah, it's rare that you do. So if you can be that guiding light, that's a beautiful thing.
So thank you.
I appreciate you being here. Thank you so much for taking the time. And, everyone should make sure to look at Ruth. I'll post a link to her bio. But if you're ever looking for a great mediator in New York, please feel free to reach out. But thank you so much for coming on, Ruth.
All right, Abe. And the same goes for you, too. California, Arizona, New York. Make sure everybody votes.
Exactly. We're coming
up on
that.
Take care.
Without an audience, we would be nothing. So I'd like to thank you, the listener, for tuning in to another episode of Mediator in the Middle. Please take the time to subscribe on your favorite podcast platform, Spotify, Apple, whatever it might be. And please feel free to refer a friend. Until next time, we look forward to seeing you, and keep calm and mediate on. Thank you.